They don't know that, Mr. Mays. It's unfair for you to say that.
Well, then they need to.
They don't know that because you'd be out of business if we just let them make all the decisions in the street.
Well, yeah, they need to.
He would be derelict. He would be derelict in his duty if he would not approach Mr. Lowry after somebody said he just broke his way into my house. He should at least talk to Mr. Lowry. Just because, you know, mentally ill people can be victims. Just because she's been unreasonable with them for 45 minutes.
Yes.
And at the last minute, she says, and by the way, the no good SOB broke into my house. No, because until the 45 minutes was up, there was no allegation that he broke his way in. Hold on, that's circular reasoning. There's no reason to think any crime's been committed until somebody suggests there has been.
How long have you been with the department?
Year and a half.
And in that time, if you had to estimate about how many OWI arrests you completed?
At that time, I would say approximately 4.
And how about now?
Over a dozen.
And were you on duty on September 15th of last year, just after midnight?
Yes, ma'am.
And around that time, were you dispatched somewhere?
Yes, ma'am.
Judge, I'd ask we sequester any witnesses. I don't know.
Any objection?
No objection.
Step out in the hallway. We'll get you back in if we need you. Thank you. Proceed. Thanks,
Where were you dispatched?
I was dispatched to 33875 Stedman Road.
Is that Huron Township?
Yes, ma'am.
Do you recall why you were dispatched to that location?
For a welfare check.
And about how long were you there investigating the welfare check? If you had to estimate.
Estimate probably about 45 minutes.
And during that time, did you make contact with the defendant?
I did.
And did you know the defendant prior to this incident?
No, ma'am.
Do you see him in the courtroom today?
Yes, ma'am.
Could you identify something that he's wearing for the court?
He's wearing the black shirt right there.
Noted.
Glasses.
Thank you, Your Honor. And at that time, was the defendant under suspicion of operating while intoxicated?
At that time, no.
Was he under investigation for any reason?
For breaking into the house and
Well, at the time that
at
you
the time?
initially,
No, ma'am.
in fact, you were just there for a welfare check.
Yes, ma'am.
And did you and the other officers eventually ensure that the homeowner's welfare was okay?
We didn't see her per se. She stated she was okay through the enclosed door inside the residence.
Perfect. And at that time, did you clear the scene?
Yes, ma'am.
Did something prevent you from leaving the location?
Yes, ma'am. The female started shouting out through the residence, through the window, I believe, and she was accusing or stating that Mr. Lowry was intoxicated and he was behind the wheel at that time. And she also stated that Mr. Lowry broke into her residence.
And what was the defendant doing at that time when she stated those things?
He was behind the wheel on Stedman Road at that time.
Was the car running?
Yes, ma'am.
Did you see him operate the vehicle?
Yes, ma'am.
And did you approach the defendant to investigate the homeowner's claims?
Yes, ma'am.
Did you ask the defendant whether he lived at that address?
Yes, ma'am.
And did he live there?
Not at the time.
Did you ask him whether he broke into the home?
Yes, he stated his son let him in. After I asked him that question, he also said that he kicked in one of the doors at the residence to make sure his wife was okay.
And did you ask the defendant whether he had been drinking?
When I approached his vehicle?
Yes.
Yes, ma'am.
What did he tell you?
At first, he stated no.
And did you believe the defendant when he stated that he was telling you no?
No, ma'am.
Why?
He had the smell of intoxicants emitting from his person.
And based on that observation, did you begin an OWI investigation?
Yes, ma'am.
Your Honor, this is where I would normally go into field sobrieties, but I believe the part at issue is the actual probable cause for the stop or the investigation.
Yep.
So I can proceed if the court wants me to, but I don't think
Any
it's
feeling,
necessary.
Mr. Mays, one way or the other?
I mean, in order to make it easy, we can break it up. So,
I don't care one way or the other.
Yeah.
I'm quick enough on my feet. I'll keep up with you.
okay. Whatever your pleasure is.
I mean, I don't think it's necessary if the only stop at issue is the stop
Okay.
itself.
Okay.
So, officer, when did you get the dispatch call?
At what time?
Yes.
At About midnight.
Okay, and what time did you arrive?
Time did I arrive? I don't recall. I would have to say probably in about 10 to 15 minutes if I'm estimating.
Okay, how long were you on scene?
Again, if I'm estimating, I don't know the exact time. Approximately 45 minutes for the welfare check.
Okay. When you arrived on the scene, well, did you mark down a stop time of Mr. Lowry's vehicle?
What do you mean by that? I'm sorry.
What time did you stop him?
I didn't stop him. I approached his car on scene after we initially cleared, and those accusations were being made by the female, stating that he was intoxicated, and at that point he was behind the wheel.
Okay, let me stop you. You arrive on the scene with how many other officers?
At first, it was me and another officer.
So just two.
Correct. At
Who-
first,
Who was that other officer?
Officer Nolly.
Okay, and then eventually other officers showed up.
Yes, sir.
So you and this other officer were the first two on scene.
Correct.
And the reason why you had been dispatched there, you said it was a welfare check, right?
Correct.
But to be more specific, a woman had locked herself inside of a bathroom, was breaking things around the house. The husband, who doesn't live there, and her two adult children were concerned about her mental state. Fair?
Correct.
She was acting crazy. Fair?
Correct.
Objection, the relevance.
Well, it goes to the credibility of the witness later on.
I'll allow it.
What's this woman's name?
I believe the first name was Heather.
Heather. Heather, I think it was Melton. Is that right?
Now, can I?
You can check.
I look?
Yeah, absolutely.
Yes, sir.
Okay, so Ms. Melton is hysterical, yes?
She was yelling at us through the enclosed door that she didn't want to speak to us, stated she had possible weapons in the bedroom.
I'm sorry, she had weapons in the bedroom?
Possible weapons, correct, sir.
So did you take that as a threat?
It did arise concern for safety for me and the other officer on scene and Mr. Laurie at the time.
Right, okay. So, and I'm assuming you've been called to situations where there's a mental health crisis before, correct?
Correct.
And the primary concern there, I mean, number one rule, of course, is officer safety, right? Yes?
Correct. Sorry.
Okay. And you want to make sure that the subject of the investigation doesn't pose a risk of harm to him or herself or others, correct?
That is correct.
Okay. And so whether or not she was suicidal, homicidal, or just having a bad day was the purpose of your being there, yes?
Correct.
Okay. She refused to allow you to have any face-to-face contact with her, correct?
Correct.
You were able to interview the two adult children?
Yes, sir.
And do you recall what their names are?
Objection, again, I don't see how this is relevant.
Mr. Mays?
It goes to the totality of the investigation, the totality of circumstances, Judge.
But the investigation was asked to when they approached Mr. Lawry's vehicle, not the prior investigation for the reason that they were initially there.
Response?
This stop is all premised on the credibility of one person making an allegation, that is Ms. Melton. So I need to know what the situation was around Ms. Melton and then what the details of the investigation revealed as to whether or not she's a credible informant, I guess.
I'll allow it.
Thank you. You interviewed the two adult children, right?
Yes, sir.
Did you interview them together or separately?
I believe there were separate interviews.
Face to face, right?
Correct.
They expressed to you that they were concerned about her mental health as to whether or not she might be suicidal. She's breaking things around the house. Both of them were in unison about that, correct?
Correct.
And you had an opportunity to interview Mr. Lowry there, correct?
Briefly, the other officer initially spoke with him.
Other officer, okay, all right, but you did have face-to-face contact with Mr. Lowry at that time, right?
I did.
And he again expressed exact same concerns, was that she was having a mental health crisis, might be suicidal, was breaking things, and they were concerned about her well-being, correct?
Correct.
At that time, did you failed to note any odor of intoxicants on Mr. Lowry's person, correct?
I wasn't really concerned
Okay.
at that point.
You indicated on direct examination that you'd been trained and that you've done a number of drunk driving investigations, correct?
As of right now, yes, sir.
Okay. You've taken the NHTSA course, the standardized field sobriety training course.
Yes, sir.
All right. You were trained that in that face-to-face contact phase 2, that there's a number of signs and symptoms that you should note to determine whether or not a person may have consumed alcoholic beverages before before they had contact with you, correct?
The officer already testified that the purpose of talking to the defendant at the time wasn't as it relates to the alcohol consumption.
Well, I guess, is the prosecutor suggesting that the signs of consumption spontaneously appeared after this? And that they weren't present during the 45 minutes that the officers were in contact with Mr. Lowry?
He already asked and answered that he was briefly talking with the defendant, that he didn't exhibit anything because he wasn't investigating him for the purpose of alcohol consumption.
Or anything else at that point.
Right.
Well, I think that it still goes to whether the officer's training and experience and qualifications.
I think it's fair ground to ask him what his observations
Thank
were
you.
during that initial
Yeah,
contact, but keeping in mind that his focus was not on Mr. Lowry at that.
understood.
Go ahead.
Yes, thank you. So, officer, you were trained that you're supposed to use your sense of sight, hearing, and smell to determine whether or not a person may have consumed alcoholic beverages before you have personal contact with them, correct?
Correct.
You're trained to look for bloodshot eyes, soiled clothing, fumbling fingers, alcohol containers, drugs, drug paraphernalia, bumps, bruises, scratches, and unusual actions by the subject, correct?
I'm gonna object again. I don't see the relevance in the initial contact.
I'm hoping he ties it up quickly,
I will.
so I'll allow it.
Okay.
Yes, sir.
You were trained to listen for slurred speech and admission of drinking, inconsistent responses, unusual statements, abusive language, or anything else, correct?
Yes, sir.
And you were trained to smell for the odor of an alcoholic beverage, marijuana, cover-up odors, or unusual odors, correct?
That is correct.
Now, during your initial contact with Mr. Lowry, you did not even detect, as you indicated, the odor of an intoxicant amongst his person, correct?
As I stated, I briefly spoke with him. He escorted me into the residence. I followed him.
Okay.
At that point, we made contact with Heather through the door, and she was shouting that she had weapons in the room and possibly wanted to harm others. So at that point, I had myself and the other officer had the defendant step outside the residence while we proceeded our
Okay.
investigation.
In this face-to-face contact, although limited with Mr. Lowry at this time, you did not detect slurred speech, correct?
No, sir, it was very brief.
And there was nothing during the personal contact phase that you made right there that would suggest to you that Mr. Lowry was in fact intoxicated, correct?
Could you repeat that? I'm sorry.
There was nothing in that interaction that you had with Mr. Lowry at that stage that would indicate to you that he was maybe intoxicated, correct?
I wasn't investigating that at that point, so
Okay.
it didn't slip my mind.
So then you go back to Ms. Melton and you focus your investigation on her, correct?
That is correct.
All three people were uniform in explaining to you that she had closed herself in that room and that none of them had had any contact with her, correct?
Correct.
Okay. You had to speak to her through the door the entire time, correct?
Correct.
You never actually made face-to-face contact with her until you'd exited the home, correct?
And not once I didn't make face-to-face contact with her at all on scene.
Never.
Never.
Okay. So you just continued to talk to her through the door?
Yes, sir.
How were you assured, given the facts and circumstances surrounding this case, that she didn't pose a risk of harm to herself or others?
We asked Mr. Lowry on scene if there were any weapons in the house, which he stated there isn't.
Okay.
We also asked her numerous times to ask her about her welfare, if she needed any medical assistance, which she denied. Us being there made her more irate. And at the time, she didn't need any of our assistance or any medical attention. So we ended up clearing the call.
So the mere fact that your presence there disturbed her more is what you're suggesting?
She did not want
I'm
to.
gonna object, that's an assumption based on something that isn't here.
No, I think it's a clarification.
She did not want to communicate with us, and she did not want to exit the bedroom at that point.
Okay. Did you get the impression that she might be under the influence of alcohol or controlled substances?
I have no clue, sir.
Okay, all right. So you cleared the scene about 45 minutes later, right?
Approximately, yeah.
During this entire time, you've had an opportunity to observe Mr. Lowry walking around and interacting with other people, correct?
Majority of the time on that call, I was in the residence in the hallway with my partner,
Yeah.
waiting for the other two officers to arrive
Okay.
on scene.
You had never met Ms. Melton before, correct?
No, sir, I have never met her.
She had no known credibility in your history with her, obviously.
This was my first time
Okay.
encountering her.
So she adamantly refuses there for 45 minutes to exit that doorway. And as soon as you clear the house, she bursts through the front door and starts screaming out profanities, claiming that Mr. Lowry is intoxicated and that he broke into her house. Yes?
I'm not sure if she exited the residence or not, but she was screaming that either through the window or through the front door of the porch.
Okay, all right. There was no reason to believe that any of her allegations were credible, correct?
She made allegations and I went to investigate those allegations if they were true or not.
Okay. You stopped Mr. Lowry's vehicle by activating your overhead lights, correct?
That's incorrect.
Give me just a moment, please. Did some too. Okay. You approached his vehicle and requested that he submit to a preliminary breath test, correct?
That is correct.
Okay.
My main focus was at that time, I didn't want Mr. Lowry driving behind the wheel based on what I smelt when I approached the car and I started questioning him about breaking into the residence. I wanted to make sure that he was okay to drive back home.
Yeah,
That was
but here's, okay. Was there any evidence that he had broken into the home?
Heather stating that he broke into the house. That's
Again, Heather is not a credible source of information, correct? She's threatening you with weapons. She seems to appear to be a risk of harm to herself or others. She refuses to open the door and she refuses to have contact with you until 45 minutes later, you're leaving the scene, right?
That is correct.
Okay. So her credibility did not go up instantaneously just because she made an allegation against someone else, correct?
Despite if the way she was acting towards us, I don't understand. I don't know how that would make her not credible at that time. Maybe she just doesn't like us. I don't understand how that would make somebody not credible.
Okay. You actually ordered Mr. Lowry to exit his vehicle, correct?
Yes, sir.
And what was the reason for ordering him to exit his vehicle?
Based on the intoxicants that I was smelling.
Okay,
I'm gonna
Him
object.
driving the
It wasn't
vehicle.
focus on the actual probable cause or?
I'm on paragraph
for
19 of my
the
motion.
stop?
I'm on paragraph 19 of the motion.
I could have continued with the actual OWI investigation.
Okay.
And had that done with time.
Anything else that's probable cause of this time?
For the stop? No.
Correct.
I
Okay.
have rebuttal questions. I don't know if you want me to handle that and then, or
I'm okay with arguing probable cause and then moving on if you want to.
I just have some questions,
Go ahead.
just clarifying questions.
Yeah, go ahead.
Thanks. Officer Sovcit, you said you just had brief contact initially with Mr. Lowry,
Yes, ma'am.
and your concern was about Miss Melton at that time, correct?
Yes,
And when someone alleges that they're a victim of a crime, do you weigh their credibility before you investigate, or as a police officer, do you investigate?
we investigate.
And isn't it true that when you asked the defendant, had he broken into the house, he in fact told you that he did force his way into the back door?
Yes, ma'am.
And in general, when you smell intoxicants, do you find that they're more concentrated in a place like a cab of a vehicle as opposed to open air?
Yes, ma'am.
I have no other questions.
Mr. Mays? You follow
Yeah, thank you. Just so it's clear, when you finally did detect this odor of intoxicants, quote unquote, you've been trained that the odor of alcohol doesn't actually have practically any odor, correct?
The alcohol doesn't have any odor.
Alcohol has almost no odor, as opposed to an alcoholic beverage or what you call an intoxicant, correct?
Yes, sir.
Okay. You couldn't tell if, when you detect the odor of intoxicants,
Mhm.
you can't tell if a person has drank wine or beer or liquor, correct?
No, sir. I can't.
Okay, all right. All that you can say is I detected this odor of an alcoholic beverage around this person, correct?
Correct.
It's a sign of possible consumption, correct?
Correct.
Okay, and then the prosecutor was asking you, does it become more concentrated inside the car? I mean, Mr. Lowry literally walked out away from you all, got into his car. Would there be concentrated vapors inside of his car?
Could you repeat that question?
Would there be time? I mean, was he even in his car long enough so that there would be concentrated vapors of alcoholic beverages in his car? I mean, here, let me make it simpler. Are you alleging that the odor of intoxicants spontaneously just was there once the focus of your investigation changed?
I'm not sure how they can just spontaneously be there. I'm not really following you.
After spending 45 minutes around Mr. Lowry, you watched him walk out to his car,
Mhm.
and then you wanted him to do a preliminary breath test because of these allegations made by the person that you couldn't get under control, right?
Yes, sir, by the allegations and
And that's where it went too straight was, so if it was consent contact, in other words,
Mhm.
if you just wanted to follow up with a few additional questions, if he wasn't being stopped formally, you claim you detected this odor of an intoxicant, right?
correct.
And immediately went from there to a preliminary breath test, correct?
I'm going to inject, it wasn't this officer.
Oh, it was a different
It
officer?
was.
Oh, okay. Oh, no.
It's a horse with a different color.
It's all dark. I can't tell one person from the next. So you didn't have the face-to-face contact with Mr. Lowry in the vehicle then?
I did.
There
I
were
did.
two at the door.
Who was the other person that was there at the door?
Sergeant Hickman.
It was in the hall.
Okay. All right. So what, were you working backup at that point, or did you do the field sobrieties?
I did, yes.
You did the field sobrieties.
Yes. Sergeant Hickman just mentioned while he was standing next to me while we were speaking with Mr. Lowry, he mentioned he asked him for a PBT test.
Gotcha. Okay.
At that point, he refused, and we conducted our SFSTs on Mr. Lowry.
And that's when That's when he was ordered out of the vehicle.
Yes, sir.
So at that point, we can agree that he is stopped at that point, correct?
Correct.
And that stop is premised entirely, well, let me back up. You didn't stop him for any civil infractions, equipment violations, or any of the traditional things that we might see in phase 1 DWI detection of the standardized field sobriety test, correct?
No, sir. Traffic stop was not
Right.
initiated.
This was entirely premised on the allegations by Ms. Melton, right?
That is correct.
And so you made voluntary contact with Mr. Lowry, detected the odor of an intoxicant, which may indicate consumption of alcohol, and based upon that, he was stopped, right?
Yes, sir.
Okay. We can agree at that point right there that there's no doubt he has been stopped. He is no longer free to leave.
Correct.
Just moments before you approached his vehicle, you're saying that he was free to leave. Yes? No?
At that point, there was no accusations being made. I wasn't investigating an OWI at that point.
No, I mean, Ms. Melton is screaming out, he's intoxicated. He broke into my house. Is he free to leave at that point?
At that point, no.
Okay. All right. So he was stopped at that point.
Yeah.
Okay. And you approached the vehicle, and that's when you detected the odor of an intoxicant on his breath, or potentially on his breath.
Yes, sir.
All right. Thank you.
Anything else?
I have no questions.
So my argument, judges, is 45 minutes of personal contact, which no doubt is completely consensual. But you would think that during those 45 minutes, the officer would be able to develop some type of reasonable suspicion that doesn't hinge on the credibility of somebody who doesn't have credibility, who hasn't had any contact with Mr. Lowry, who's been closed up behind this door the entire time, is threatening officers and that sort of thing. So the question then becomes, did they stop him, or did it continue to be consensual contact? And we know that at some point there, whether it's approaching the vehicle because she's screaming, or at the moment that he detects the odor of an intoxicant, at that point he stopped. So lights on or not, he stopped. He's no longer free to leave. So
Let me stop you. I think it's pretty clear from the officer's testimony that the stop, and I hate that phrase because when you hear stop, you think traffic stop. Before he got to the car and could smell the odor of intoxicants, the officer thought Mr. Lowry was stopped because I have to investigate this alleged break-in. That's the way I understood your testimony. If I misstated it, please correct.
That's correct.
All right, so let's start from that premise. He stopped before his nose gets into gear.
okay, so there's no evidence of a break-in, and there's no credibility to the person that they're investigating. So I think it's the case that I was focusing on was People versus Pagano, the 911 caller that makes no allegations of intoxication or any specific allegations that would substantiate what they reported. In other words, we have a person who appears to be a crazy person who's acting irrationally. Just because that crazy irrational person makes an allegation by pointing at someone doesn't give cause to stop that person. We have to weigh, like under Illinois v. Gates, I guess, we have to weigh the totality of the circumstances and look at that person who we're having a really tough time dealing with in terms of even getting her to even open the door and stop threatening us, so.
Response?
This is a classic investigatory stop. The homeowner made an allegation that the defendant had broken into her house, that he was intoxicated. The defendant, in fact, admitted that he had broken into the house. While he didn't admit that he was intoxicated, the officer testified that he smelled of alcohol. Even though he previously had several brief contact with the defendant prior to, at this time, his investigation became an OWI investigation. According to People vs. Rizzo, they concluded that an odor of intoxicant standing alone is sufficient to provide police officer with reasonable, articulable, and particular suspicion that the motorist had consumed intoxicating liquor. And that began the OWI investigation. I think it's very clear that he had a reasonable and articulable suspicion that the defendant had consumed intoxicants. Whether or not he admitted to it, not everybody does. We see that out every day, but In this particular case, the officer was doing his job by doing an investigatory stop. And that shifted from the stop, well, the investigation itself began as a welfare check. And then turned into an investigation as to these allegations of breaking and entering and intoxication. Then it shifted again into operating while intoxicated because the defendant was operating his vehicle at the time and he smelled intoxicants. I think there was more than enough probable cause to for the
Mr. Mason.
And I disagree under Rizzo. Rizzo is a traffic stop. Rizzo is where the officer has just moments to decide, hey, am I going to briefly detain this motorist to determine whether or not to confirm or dispel that this person may have consumed too much. In this instance, the officers are with Mr. Lowry, whether it's this officer or jointly all officers are with him for 45 minutes or more. They have plenty of opportunities to determine this man's not intoxicated. There's no reason to even pause. There's no reason to stop him from going to his vehicle. There's no reason to investigate him for any crime. They do this complete and thorough investigation there at the house, and then entirely based upon Ms. Melton's statements and screaming these statements, not just in a normal tone, but basically to try to hurt Mr. Lowry. They know that these statements are not credible.
They don't know that, Mr. Mays. It's unfair for you to say that.
Well, then they need to.
They don't know that because you'd be out of business if we just let them make all the decisions in the street.
Well, yeah, they need to.
He would be derelict. He would be derelict in his duty if he would not approach Mr. Lowry after somebody said he just broke his way into my house. He should at least talk to Mr. Lowry. Oh, just because, you know, mentally ill people can be victims. Just because she's been unreasonable with them for 45 minutes.
Yes.
And at the last minute, she says, and by the way, the no good SOB broke into my house. I would be upset if they didn't approach him and say, what she said, she broke into the house. And he said, yeah, my son opened the door and I forced my way in, or whatever he said.
They could have said, they could have asked those questions, and I'm sure that they did ask those questions if we talked to all the officers.
He did. He testified that the questions were asked.
During the 45 minutes that everybody was there.
No, because until the 45 minutes was up, there was no allegation that he broke his way in.
Right. So there's no basis to believe that he broke in during the entire 45 minutes either. So they know that he's not intoxicated.
Well, Mr. Mays,
they know that he didn't
hold
break
on.
in.
That's circular reasoning. There's no reason to think any crime's been committed until somebody suggests there has been.
This should be treated as if it were a 911 call, where we know that the person who's calling has no information whatsoever. None. It's nothing more than a naked allegation and has not described any specific conduct that would describe impairment or intoxication.
But you're mixing apples and pork chops. The initial stop was to see if this guy broke into the house. That's what he said. I stopped him before my nose got into gear. I stopped in his head. Mr. Lowry was stopped after she said he broke into the house. When he approached the vehicle and at that point noticed the odor of intoxicants is when his focus became a mix breaking and entering and OWI possible investigation.
He's instructed to leave. So he gets into his car, and as he's pulling out, Ms. Melton starts screaming that he broke into the house and was intoxicated.
Right, and this officer's testimony was, as he approached Mr. Lowry getting ready to leave, as he approached him, in his mind, he was stopped. Because I want to ask him a question.
Let me ask some follow-up questions.
Please do.
So she comes out and she's screaming that he broke into the house and he's intoxicated. After he's been told to leave, right?
Yes, sir.
Okay.
I didn't, for the record, I didn't tell Mr. Lowry to leave or anything like that. I don't know if any other officers told him to leave, but I did not tell him Mr. Lowry.
But certainly at that point, none of you cared if he left.
No, at that point, there was no crime.
So you are stopping him because of the allegation of the break-in, or you were stopping him because of the allegation of the drunkenness?
Both. She was screaming.
Tell me what evidence that you saw that he had broken into the home.
Well, the house was in disarray. On my body camera footage, you can see when we walk around, there's objects thrown everywhere. There's stuff broken.
Which is consistent with her breaking things. And all three statements by all three people that she was out of her mind and breaking stuff and was suicidal or homicidal, correct?
she was breaking stuff but no statements were made that she was suicidal at that time.
Okay. Was there any evidence that you saw that Mr. Lowry broke into the house?
Other than the stuff being in disarray, no, sir.
Okay. And again, you had 45 minutes to investigate this before he was leaving, correct?
Investigate what? Clarify that.
To investigate whether or not he'd broken into the house.
There had been no allegation that there was a break-in, so why would he investigate that?
Okay, fair. So,
They're there for a welfare check.
okay.
45 minutes on a welfare check. It's only at the 46th minute that it became a possible investigation for something else.
So you believe that you had a reasonable and articulable suspicion that he had broken into the house when you stopped him?
Heather made the statement that he broke into her house and he was drinking. That's why I approached the car to investigate more.
Well, she didn't say that he was drinking. She said that he was intoxicated.
Intoxicated, correct.
And with no details of either allegation, correct?
With no further details.
Right.
Correct.
Okay. You believe that that gave you a reasonable and articulable suspicion that he had broken into the house and was intoxicated.
At that point, sir, I do have to conduct my investigation. If he
Do have to. No, you don't have to do anything. You're not obligated to do anything. What would you mean that you are obligated to do that?
if somebody's stating that an individual broke into their house, I would conduct my investigation. If I chose to ignore that, and he did break into the house, we have a victim now that did not have justice because I didn't investigate.
Okay. Well, you have a victim who you've never even made face-to-face contact with, correct? I mean, I don't want to be overly critical of this, but if she had killed herself or killed somebody else after you guys left, after you hadn't made any contact with her, well, she's threatening officers with weapons. You found that to be credible when she said he broke into my house, even though you hadn't shared more than a word with her, and not even a word with her face to face, right?
That is correct. She made statements that
Okay.
he broke.
So
into
if
my
somebody
house.
says something, doesn't matter if they're crazy, that mandates that you follow your duties and stop the person, correct?
Correct. I mean, with all due respect, can I say something real quick?
Nope. So the very first thing that you do to investigate whether or not Mr. Lowry has broken into the house, just so it's clear, you or your partner demand a PBT, correct?
No, the first thing they do is say, did you break into the house? And he said, yeah, I was let in and I forced my way in. The first thing they did in the investigation is ask a question. I was listening to the answers of the questions you asked.
I don't believe that that's what happened.
That's what he said.
Okay, hold on.
She said you broke into the house. What happened? My son was here and I forced my way in.
Can we zoom up the video?
I don't know if we can or not. I don't have the video loaded anywhere.
I've got the video. I just need to zoom into play.
Yeah.
The zoom's on. Yeah, zoom's on.
Correct.
Okay. Now, why was he ordered to exit the vehicle?
At that point, I was handling it as an OWI investigation.
Fair enough. But we can agree that he was ordered to exit that vehicle, correct?
Yes, sir.
Now, you understand that you are almost universally allowed to order a subject to exit the vehicle for officer safety, correct?
Correct.
There was clearly no concern about officer safety because Mr. Lowry had been in your presence for almost 45 minutes to an hour, right?
That's correct.
Okay. So you weren't ordering him to exit the vehicle for officer safety, correct?
At that point, no.
Right. You were ordering him to exit the vehicle so that he would be compelled to perform field sobriety test, correct?
Correct.
Okay. Did you indicate to him? Oh, I'm sorry, let me back up. We can agree that the preliminary breath test that was offered to him prior to the exit order, that would constitute as a search, correct? Requesting a person to submit to a PBT is a search, correct?
Correct.
And that is the reason why you ordered him to exit the vehicle, correct?
No, I ordered him to exit the vehicle because at that point I was going to conduct an OWI investigation.
Those tests are completely voluntary, correct?
Yeah,
HGM walk and turn and one leg stand are all voluntary, right?
yes, sir.
Did you explain that to Mr. Lowry?
I did not know.
So you ordered him to exit the vehicle and he had no choice about that, correct?
Correct.
Okay. After ordering him to exit the vehicle and not for officer safety, you then ordered him to perform these tests, correct?
I told him I was going to put him through tests and he said he performed them. I don't know if I ordered him or not, but I did tell him to conduct these tests.
It was never made optional for him, correct?
I know I didn't give him the, no.
And then after going through all that, you then did this preliminary breath test afterwards, right?
Correct.
So an attempted search followed by an exit command, followed by these field sobriety tests, followed by another search, correct?
By search, you mean the breath test?
Yeah.
Yes, sir.
Okay. All right. And then you arrested him and asked him to submit to a blood draw.
Yes, sir.
Why did you ask for a blood draw?
We don't have a data master machine at the station, so you go to the Henry Ford to get blood draws.
There was no machine at that time, or
At
there's
that
no?
time, at that time.
You've got one now.
We have one now, yes, sir.
Okay. All right. Did you ask him if he was diabetic before you?
I don't believe I did ask him that, no.
Okay. You understand that you're supposed to advise a person who is diabetic or a hemophiliac that they don't consent to blood.
Yes, sir.
All right. Thank you very much. No further questions.
Any question?
I have no question.
You can step down. Again. Any other witnesses?
I don't have none.
Argument.
I'm good, Judge. I think that they've established at least enough. I would ask that the court suppress the HGN test, though, based upon the officer's testimony today for further purposes. But I think that the rest of it kind of goes forward.
No objection.
Granted.
Thank you, Judge.
Anything else?
No.
Take some time pre-trial?
No, we can't.
I already made an offer.
We are forced
No, that's all
to
right.
go to trial.
All
So
right, do we have a date? Have we done that yet?
what's that?
Have we had a date picked yet?
No, if you want to, we can.
Come on up.
Let me go grab mine.
Yeah, go ahead.
I've been going since 6:30 this morning. I got a discovery packet at 9 a.m. in Novi. So I had to get into the office at 6:30, start watching videos. And these in-person videos, in-person in Novi, in-person in Plymouth, and then of course in-person here.
Isn't it great?
I can't go this long.
You had to sleep more.
Can't go this long.
Go to bed earlier.
I went to bed at 1.
That's what I mean. Go to bed earlier.
But that was early. I was watching Raiders and Lost Ark, the newest one.
Oh, well, at least it was for good reason.
Spectacular. I turned to my wife. She said, that wasn't too bad. I should probably watch the originals. I said, wait, what? I said, how did we even get married?
We're not that friendly.
Well, it was worse because I started playing the original at 1 a.m. saying, you gotta watch this one, right? And I caught her looking down at her laptop repeatedly. What are you doing? This is the original. Stop looking down at your computer.
What are we looking at?
You doing a jury?
Yeah. Well, I'll think about it. I'm talking.
Well, let me know soon.
I will.
You know how these are hard to find.
Yeah.
That's a regular doctor.
This courtroom moment turned intense because this wasn't just about facts. It was about what actually counts as evidence. A man stood in court, accused of driving under the influence, but the defense pushed back hard. They argued something simple but powerful. The police were on scene for 45 minutes, and during all that time, there was no sign of intoxication. No slurred speech, no clear behavior, nothing obvious. Then, suddenly, everything changed. Only after a woman who refused to even come out of the room started shouting accusations. That's when the officer shifted focus, approached the car, and claimed he smelled alcohol. The defense didn't hold back. They questioned everything: her credibility, the timing, even the officer's judgment. Was this a real investigation or just reacting to a chaotic situation? Because if the entire case starts from one unstable accusation, does it even hold up? But the judge saw it differently. He made it clear: police don't ignore accusations. They investigate them. And once alcohol was detected, that was enough to take it further. So here's the real question. Should a case depend on one person's accusation or on clear, consistent evidence?